Okay, this is CPL 170.10. It's an overview, but it's not the whole thing, so go read it. All right? It's arraignment upon the three infos, which is information, simplified information, and prosecutor's information, and misdemeanor complaint. Remember, 170, if you saw the opening video, only deals with those four. Okay, and this is arraignment upon those accusatory instruments. All right, let's begin. Okay, so following the filing of any of those accusatory instruments in the local criminal court, defendant must be arraigned thereon. Okay, so once the accusatory instrument is filed, they're going to arraign his or her ass. Okay, now the defendant must personally appear at such arraignment, but you know there's got to be exceptions. 20 million exceptions for us to memorize. So generally speaking, defendant must show up personally at such arraignment, except when a simplified information is filed. There's a piece of hair in my damn eye. Okay, simplified information is filed. There's going to be procedural laws provided within that simplified information. So the defendant's going to follow the procedures provided by law applicable to all offenses charged in the simplified information, and if followed, would dispense with an arraignment or personal appearance of the defendant. Okay, so first you got to follow what's in that simplified information. Okay, B, in any case in which defendant's appearance is required by summons or appearance ticket, court in its discretion may, for good cause shown, permit the defendant to appear by counsel. Summons, appearance ticket, defendant is shown good cause. Court may permit the defendant not to have to be there in person, but to have his counsel be there. Okay? All right. Number 2, arraignment. This is how it goes down at the arraignment. Okay. You got to remember this one. I've seen questions on it. So defendant is presented with two things. They're informed of their charges and they're given a copy of the accusatory instrument. Furnished with a copy of accusatory instrument and informed of the charges against them. All right, I think that's an easy one to make a card and remember. So pretty straightforward. Okay, number 3 is going to be the defendant's right to aid of counsel. So this number 3 and the things under here is all about the defendant knowing his right for counsel and obtaining counsel and what may go down. So defendant right to aid of counsel during every stage of the action. He has a right to counsel during every stage of the action. Okay, if defendant appears without counsel, the court needs to let him know his rights. Okay, and here's what he can do if he doesn't have counsel at the time of the arraignment. A, there can be an adjournment for the purpose of the defendant obtaining counsel. So the court can set an adjournment so he can go find counsel. B, the defendant can communicate free of charge by letter or by phone by law enforcement facilities. So if he's locked up, he could send a letter, he could be on the phone. And again, okay, and as far as the phone calls, it's in the US, this is important, or PR, for purpose of obtaining counsel and also informing relatives and friends that he or she's been charged with an offense. Okay. C, the court can assign counsel if he's financially unable. But, of course, there's an exception. Not for traffic infractions. For simplified information, the defendant has a right to have supporting depositions. Again, this is not the whole section. You can go read it. Thank you.